Good morning, good afternoon and good night learners. Let's learn the law. Civil Justice and Tort Law. Unit 1 An Introduction to Civil Law. Civil law is a major branch of the law in England and Wales. It is distinct from criminal law. Civil law can be described as an umbrella term, as under it there are many different categories of law, one of which is tort law, which will be covered in later units of this module. Some of the other categories of law under the umbrella of the civil law will be introduced in this unit. This unit will explain how the civil law provides a framework for regulating people's lives, our relationships with each other and with the state. Some of the key differences with criminal law will be summarized and the different purposes of the civil law explored. It is one of the roles of a lawyer to resolve civil disputes, and this will also be a focus of this unit. This unit will also introduce the concept of judicial remedies, and their appropriateness in specific circumstances. This section will briefly outline some of the basic concepts regarding the law in England and Wales, to provide context to understanding the civil law. The definition we use of law is that it is the body of rules following from formal enactment which a particular state recognizes as binding on its members. This definition highlights some of the important characteristics of lawmaking and the enforcement of the law. It is a body of rules. It is recognized by the state. It requires formal enactment. It is binding upon its members. The law in England and Wales derives from two principal sources, common law and statute law. Common law. Common law is also referred to as case law. It originated in medieval courts through judicial decisions. Over time, a body of legal principles developed from the judgments of the courts. These are called cases. An example of a case used in this module is Donahue v. Stevenson, 1932. Statute law. Over time, the laws created by Parliament have become more significant and numerous. In modern common law systems, laws created by a state's legislature, known as statute or legislation, take precedence over case law. In the United Kingdom, statute is created by an Act of Parliament. An example of an Act of Parliament used in this module is the Defamation Act 2013. The civil law. When a person thinks of the law, they often consider people in handcuffs, suspects being interviewed in police stations, or individuals being cross-examined in courtrooms over crimes that they are suspected of having committed. However, not all the law involves flashing lights and sirens and the prosecuting of crimes. In fact, by far the largest branch of the law is the civil law. Every day, the civil law impacts on the lives of people within society. For example, if you are sitting on a chair at a computer reading this right now, civil law is everywhere, whether in the safety regulations for your furniture or electronic equipment, or in the tenancy agreement or mortgage for your house. The civil law governs the registration of your birth, and the issuance of your death certificate. It is a framework of rules which guides and governs what people do in society. The civil law allows for the function of the economy and the distribution of resources, and it protects rights and liberties, including by giving persons the ability to resolve complaints they have with one another, and for these resolutions to be enforceable by the state. For instance, if a person agrees to buy an item from a seller and pays the agreed price, that person can expect to receive the item. Both the buyer and the seller understand the rules of engagement, how they are expected to behave, and have confidence in the buying and selling arrangement. The expectations of both the buyer and seller are recognized by the civil law. If these expectations are not met, the aggrieved party can take legal action, and the resolution can be enforced by the state. This section has looked at the different types of law which fall under the umbrella of the civil law. The next section will look at how civil law can be differentiated from the criminal law. Differences between criminal and civil law. There are many differences between criminal law and civil law, which you will learn about in this section. Who brings the proceedings? The distinction between criminal law and civil law is best explained by looking at the legal consequences which follow when a breach of the law has occurred. If a crime has occurred, criminal proceedings will follow, and where a civil wrong has occurred, civil proceedings will follow. In criminal proceedings, when someone is charged with a crime, the proceedings are brought by the state in the name of the Crown. The lawyers who act on behalf of the state are called the prosecution. The decision to bring a prosecution is taken by the Crown Prosecution Service, CPS, in England and Wales. In criminal law, the prosecution acts on behalf of the state to establish that a crime has been committed by the defendant. In civil law cases, the decision to take proceedings rests with the individual or party concerned. The proceedings are normally brought by the claimant or applicant, depending on the type of case, and the defendant or respondent opposes the case. In older cases you may hear the claimant being referred to as the plaintiff, but this language is not used in more recent cases. Results. Criminal proceedings often result in offenders being fined or sent to prison. Civil proceedings often result in compensation being paid, amongst other remedies that will be discussed throughout this module. Terminology. The terminology in criminal and civil proceedings is also different. There is no such thing as a civil offense. Instead, it is correct to say civil wrong. It is correct to say criminal offense. In civil law, it is incorrect for someone to be found guilty of committing a wrong. Instead, it is said that they are liable. In criminal law, it is said that someone is guilty when they commit an offense. In civil law, it is incorrect to talk of a defendant being prosecuted, so it may be of interest to know that the phrase trespasses will be prosecuted is often incorrectly used because trespass is a civil wrong, although there are some exceptions where trespass can be a criminal offense, e.g., on railways. It is correct to say that a person can sue or be sued in civil law. To sue a person is to initiate a court case against them in civil law. The burden of proof and the standard of proof. Civil law and criminal law also deal with the burden of proof and the standard of proof in different ways. The burden of proof means identifying who has the responsibility to prove their facts, or facts in issue, in a case. In criminal law, the burden of proof is normally on the state to prove someone is guilty of a crime. This means that the prosecution must prove all the aspects of the alleged crime for the defendant to be found guilty. In civil law, it is up to the claimant to prove the case, so the burden of proof rests on them. The standard of proof relates to how much is required to be proved in a case. In criminal proceedings, the state must prove the defendant is guilty of the offense or offenses to a standard of proof which is beyond a reasonable doubt. In civil law, by contrast, the standard of proof is on the balance of probabilities. This means that if the court believes that there is more than a 50% probability that the defendant wronged the claimant, then the claimant will have a favorable outcome in their case. The difference in the standard of proof needed in criminal and civil law means that it is harder to prove a case to a criminal standard than a civil standard. This reflects the fact that criminal law can involve the sanction of a prison sentence and a criminal record, whereas civil cases often involve the payment of money. This, it is considered, is a less severe imposition. In this section, the umbrella term of the civil law was explored, and the main differences between criminal and civil law were outlined. The following section will consider how the civil law impacts on the lives of people, specifically with regards to how it regulates and recognizes the different statuses they have within society. Civil law status, recognition, and relationships with the state. One of the functions of civil law is to give recognition to the different and varied statuses that we hold throughout our lives as we interact with each other and society. Legal status, in its various guises, provides the framework of how we interact with other people, or are recognized by other individuals and the state. For instance, someone may have legal statuses as a British citizen, or as a married person, or as an employee of a company. These different statuses are recognized in law and often give rise to rights and accompanying responsibilities. At different times, individuals in the United Kingdom are required to have events recognized and registered by the state. For example, when a child is born, there is a requirement that their birth should be registered within 42 days. This is governed by the Births and Deaths Registration Act 1953. The status of a parent is also thereby recognized, which can then result in them having obligations for caring for a child, including their financial maintenance. Section 15 of the same act also provides that when a person dies, their death is registered. However, legal status goes beyond merely having births and deaths registered. Individuals have legal status for a multitude of different reasons. This section considered how the law recognizes our different statuses. The next section will move on from considering what the civil law is and how it impacts people within society, to what happens when people have disputes involving the civil law. It will discuss how legal disputes are classified into different areas of law, and the outcomes that people seek at the end of their legal disputes. Civil disputes, classifications and outcomes. One of the primary functions of the civil law is to resolve disputes between parties. Therefore, one of the main roles of a lawyer is to provide representation for parties who are seeking to resolve disputes, and to aid them in their ability to do that. Being able to understand what a dispute is about, and therefore what category of law it falls into, is a key skill for a lawyer. Many lawyers specialize in specific areas of the law, so it may be they consider that the case that has come before them could be better resolved by another colleague, or by another firm. For example, if someone specializes in personal injury claims, they may not have the skills or knowledge to resolve a complex commercial litigation dispute, or vice versa. Outcomes. When people have disputes, they seek an outcome or a remedy for the wrong they consider has happened to them. Sometimes people can come to an agreement with the person who has wronged them instead of having to go to court, through negotiating with them, or through another form of non-judicial dispute resolution. When a person goes to court, they are generally seeking a judicial remedy. To proceed with litigation, a person should be asking if what they seek is attainable. Legal practitioners may refuse to take a case on if they feel that there is no realistic chance of there being a successful outcome for the claimant. There are many different remedies for wrongs committed in civil law, with compensation being one of the principal remedies. However, sometimes compensation may not be the appropriate remedy. A party may be wishing to prevent another party from doing something or compel them to perform a specific action to remedy a wrong. These remedies can be agreed outside of the courtroom, or obtained within it. At different points in this module, the legal terms for a number of these remedies will be introduced and explained in more depth. Each dispute will turn on the facts, and sometimes a combination of outcomes is needed. This section briefly looked at legal disputes, classifications of law, and outcomes. In the following section, the concept of civil justice will be introduced, which is what people seek when they take their disputes to court or seek alternative dispute resolution. Civil justice. What does justice mean? The pursuit of justice is the key aim of a legal system. The Oxford Dictionary of Law, 2020, describes justice as a moral ideal that the law seeks to uphold in the protection of rights and punishment of wrongs. When people seek dispute resolution or take their cases to a civil law court, they are seeking justice for the wrongs that have been committed against them. Justice is very difficult to define, and how each of us attempts to explain it depends on our individual perspectives. It is a multifaceted concept and means different things depending upon expectations that we have, which can be derived from our cultural, religious, political or social beliefs and experiences. This section looks at what civil justice means. The following section links the previous discussion of compensation with civil justice, considering the limits of compensation to redress loss or harm. The limits of recompense in civil justice. The payment of compensation by a party who has caused another loss or harm is one recognizable feature of civil law. However, some might suggest that payment of compensation can never right some wrongs caused, such as physical or mental injury, the death of a loved one, or hurt to one's pride or self-esteem. Compensation in some ways can be a blunt tool to seek to remedy some wrongs. This section will explore the appropriateness of compensation as a remedy by looking at some of the experiences of the Windrush generation. The Windrush generation refers to people who came to the UK from colonies of the British Empire after the Second World War and before 1973. The MV Empire Windrush was one of the first ships to arrive to the UK, bringing people from Jamaica at the invitation of the British government to fill labour shortages arising from the effects of the war. Despite being resident lawfully for many decades and living and working in the UK, as a result of the development of immigration law, many of these individuals lost their immigration status. New laws had created an immigration system where individuals from colonies and the Commonwealth no longer had the same rights of residence in the Britain that they had previously enjoyed. The UK government had kept no record of those granted leave to remain, and a series of policies made it gradually harder for the Windrush generation to prove that they were lawful citizens. As a result of this, many people lost their jobs, homes, and other rights. Some were refused NHS treatment and access to healthcare. The government eventually accepted that there had been wrongdoing as a result of their policy, and the then Prime Minister Theresa May apologised for their treatment. A compensation scheme was set up. This unit introduced you to the concept of the civil law and outlined differences between the criminal law and civil law. It introduced you to the variety of situations covered in the civil law, and how the civil law recognizes the different statuses individuals have within society. Civil disputes were discussed, as well as means to classify them within the umbrella term of the civil law. The concept of remedies in civil law was also introduced. The meaning of justice and the limits of providing compensation to right wrongs were considered. Throughout the unit you have been note-taking and you have reflected upon this. You will use and develop your reflective skills throughout this module. You should now be able to explain some of the different ways that civil law disputes are classified. Describe key differences between civil and criminal law. Express how the civil law frames our lives. Describe justice as it relates to the civil law. Please like, comment and subscribe. Good morning, good afternoon and good night learners.